Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 375 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by my new book, The Complete Compliance Handbook, which will be published in April by Compliance Week. You can check out more information on my new book at www.fcpacompliancereport.com, where it's available for pre-purchase. As an extra added benefit, if you would like a paper on the 10 hallmarks of an effective compliance program, which is based upon the information in my book, I'm happy to make that available to you as well. You can text FCPA FOX, that's FCPA FOX, all caps, to the number 44222 and receive a complimentary copy of my paper on the 10 hallmarks of an effective compliance program. That's FCPA Fox, text that to 44222. Today I continue my exploration of the implications from the Supreme Court decision in Digital Realty Trust versus Summers. I have Steve Durham. Steve is a white-collar and whistleblower practitioner at Labaton and Sucharow in Washington, D.C., and he talks to us about the implications of the Digital Realty Trust decision from the perspective of the whistleblower and the Whistleblower Council. I think you will find it a fascinating exploration of the both intended and unintended consequences of this most recent Supreme Court decision on the definition of who is a whistleblower. This is Tom Fox. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for another episode. Today, we continue our exploration of the impact of the Digital Realty Trust versus Summers case. I have back with me Steve Durham. Steve is a former DOJer, and now it handles or helps whistleblowers in Dodd-Frank whistleblowing actions. So, Stephen, with that short introduction, welcome and thank you for taking the time to visit with me.
Tom, thank you. Thank you for having me back on the program. It's a pleasure to be here.
So this case, although as we were discussing prior to coming on board, was a 9-0 decision, and we both, I think, agreed on the legal reasoning and the legal decision. The practical impacts on this case in a wide variety of situations, settings for individuals, for corporations, for the Securities and Exchange Commission, for people like yourself, are going to be wide, varied, and deep. And I really am trying to help my listeners understand some of the different perspectives on where this case may take us. So most of my listeners are aware of the case, but just briefly, the Supreme Court narrowed the definition of whistleblower under Dodd-Frank to be persons who submitted information to the Securities and Exchange Commission, meaning if someone went to their employer, their company first, or initially, they could still be terminated and not have Dodd-Frank protections. So with that, Stephen, I see a wide variety of implications. Where do you want to start on this one?
I think the best place to start is just, what the opinion holds itself and the implications of that. So the opinion says, as you point out, is that if you do not report to the SEC Office of the Whistleblower, you are not a whistleblower, as the term is defined under Dodd-Frank, and accordingly, because you're not a whistleblower, you're not entitled to avail yourself of the protections, the employment, the anti-retaliation protections that Dodd-Frank provides. So now you're still entitled to avail yourself of whistleblower protections under Sarbanes-Oxley. And so it's not as if you don't have any protections at all, any anti-retaliation protections. But the important takeaway from this, Tom, is that the Dodd-Frank protections were in many respects superior to what was written into Sarbanes-Oxley. And in three material respects, if I could just for a moment. So Sarbanes-Oxley has a 180-day filing deadline. Whereas Dodd-Frank, the person can file up to 6 years from the time of the violation. So there's a very important time frame there. Another important difference is Sarbanes-Oxley has an exhaustion requirement. So you have to first go to the Department of Labor and file administratively. Whereas with Dodd-Frank, the whistleblower is entitled to file directly in the United States District Court. And then another important takeaway, another important distinction is that with Sarbanes-Oxley, the award is for back pay, whereas with Dodd-Frank, Dodd-Frank recognizes double back pay. And there's some other differences as well. So, the bottom line is if people want to avail themselves of the protection of Dodd-Frank whistleblower anti-retaliation protections, then now they have to file with the SEC, and that has large implications, as you stated.
So one of the immediate things I would say from the corporate perspective is, I don't know if you were recall, but during the rulemaking process and commentary, corporate America wanted whistleblowers to be required to report internally first. And from my perspective, as someone who works on compliance programs and the nuts and bolts of compliance, that reason is so that companies will have an opportunity to remediate, take care of the problem. It may be that the problem really is not does not rise to a securities law violation, and perhaps there could be some education. But certainly, if there's a problem, if there's a violation, or anything in between, the company would have the opportunity to remediate it, self-disclose as appropriate, but without that opportunity, obviously, if you go to the SEC directly, a company may not know about it, and this may allow, or not allow rather, but the effect would be that a problem could fester, and it could, when many things fester, they get worse. So something that could be a problem could raise itself to becoming a violation. If it's a violation to start with, it could be compounded and continue on. And obviously, by going to the SEC directly, the company would not have the opportunity to self-report and avail itself of any discounts or goodwill or cooperation credit that they could receive by self-reporting. So I really see this decision as something that is not in the interest of corporate America. Do you find that to be accurate, or is it something else you see?
No, I agree with you, Tom, and that's been our argument and our practice's argument from the outset, is that, in some ways it provides an incentive, and now you have to go to the SEC when, and in the past, and we always, just as an aside, we almost always, not always, but in most of the cases, we encourage our clients to report internally. And the reason we do that is because companies have put time and resource into internal reporting and internal investigation mechanisms. And many times, the companies, as you point out, you can have an opportunity to take a look at it. And if there is remediation that needs to be done, many times the companies can get out in front of problems and mitigate those problems and save a lot of heartache. But what the decision will do, and I believe in some ways it's an unintended consequence, is that now employees who feel that they want to avail themselves of Dodd-Frank anti-retaliation, they have to go to the SEC. So the question then, there are a number of questions, but one question is this, is will that encourage more people who would report internally anyway? Will that encourage them to bypass the internal reporting system entirely? And that's an open question. I think if somebody is predisposed to report internally, they're probably going to continue to report internally. Our advice to most of our clients is going to be report internally, because if you don't report internally, at the end of the process and during the process, the Office of the Whistleblower at the SEC, they want to know, did you report internally? And if you didn't, why not? And you better be prepared to have a pretty valid reason. And sometimes there are valid reasons. But I think that also the other effect here is that the Office of the Whistleblower at the SEC is going to get a higher volume of reports coming in. And last year, we know from its own reporting that the SEC Office of the Whistleblower received over 4,400 complaints. The SEC, as an entity, received 20,000. So the volume of 4,400, which is, a number every single day, there's complaints coming in. that volume, I believe, based on this decision, is going to increase. So, and then there are questions as to, how are these additional tips going to be received and processed? And the end game here, the ultimate goal in this, as the Supreme Court has pointed out, the core objective of the Dodd-Frank whistleblower program is to aid the Commission's enforcement efforts by quote, motivating people who know of securities law violations to tell the SEC. So another open question is the SEC, as a result of this decision, the Office of the Whistleblower, is the SEC going to get, they're certainly going to get a higher volume, Tom, but are they going to get a higher volume of quality information? That is information that ultimately leads to an enforcement action. And that also, I think, is an open question.
So that really is 2 points. I had focused on the first one, which was the quantity of the complaints that would go to the whistleblower's office, the quantum. But you've really identified another issue, which may, at the end of the day, may be equally, if not more important, which is the quality of the complaints. Could you maybe flesh that out a little bit? Because I think in terms of unintended consequences, this could have significant impact on the office of the whistleblower.
Sure, I'd be happy to. So the way the program operates is that the SEC receives information on what they call a TCR form, a tip complainer referral form. And the tip complainer referral form, the more detailed the information, the better chance that somebody has to become a successful whistleblower, because the SEC is looking for detailed, original information that's independent. So the quality of the information is a large driver. So we represent clients, and we're a very selective practice. We take only about a dozen cases a year, but the cases we take, we vet very carefully, and we try to handicap, because we want to make sure that the information that the SEC gets is very, very high quality information. Now, that information has to lead to an enforcement action. So even if it's truthful, even if it's good information, even if it's helpful, if it doesn't lead to an enforcement action, then there's no whistleblower award. So it has to lead to an enforcement action. And if it does lead to an enforcement action, it has to be significant, because the SEC will only pay a whistleblower if the enforcement is $1 million or more. So we're constantly trying to, and we get dozens of inquiries a week in our practice. And what we're trying to constantly do is we're trying to vet information. Is this a good case? Will it lead to an enforcement action? Will it be significant? Is this a good client? Because the client has to come in with reasonably clean hands. The client can't be involved in committing crimes or dishonesty or misleading information. So we're constantly in the process of trying to evaluate the strength of cases. And so, it goes back to what I was saying, and your point is, the objective here is for the SEC to encourage people and motivate people who know of securities violations that are of high quality. And so what does this decision do? Hopefully it encourages people on the margins to, when they otherwise wouldn't, they say, well, okay, I'm going to report internally. And I'm going to leave it at that, because, I'm just not, I'm not cut out to be a whistleblower. I don't want to be a whistleblower. There may be situations where now, given the strong anti-retaliation provisions of Dodd-Frank, people say, well, I'm sticking my neck out here by reporting internally. And they are. There's no question about it. Even in anonymous reporting hotlines, you kind of stick your neck out there a little bit to try to do the right thing. But so now people may say, the decision tree may operate in the following manner. Well, I'm going to report internally, and I think we have a pretty good compliance system. But I don't have any guarantees, or, I may not trust the compliance system. And I've certainly heard that in our practice. So what should I do? Because I don't want to be fired. I don't want to be demoted or isolated or retaliated against. How do I deal with this? And the answer is, you need to go report to the SEC Office of the Whistleblower. And then at that point, you trigger the enhanced protections provided by Dodd-Frank. So again, Tom, a lot of open questions, but these are the kind of questions that we're already dealing with in our practice. And, that's what we do. I mean, that's our specialty.
So, Stephen, you raised your discussion raises two more points specifically to the SEC and the Office of the Whistleblower that I'd like to go into. First of all, it occurs to me that if there is a greater number of whistleblower complaints, a plethora of claims come in, tips, whatever it may be, that the SEC, I don't want to say will be overwhelmed, but they certainly could get a large number, which would kind of slow down their investigative process and elongate the time between an initial report of a whistleblower and a final resolution with a company, causing, if not staleness, certainly a longer period of time. And if a company is doing something, frankly, not that the conduct would get worse, but the fine and penalty could increase. The second thing is, frankly, I think this decision I'm not sure if it puts more pressure on the SEC, but it certainly puts more pressure, I think, on people like yourselves and people with a whistleblower practice, because I think the SEC will now rely on people who do the vetting that you and your firm do and present the information in a manner that can be easily translatable into an enforcement action. How do you feel about those two issues?
I think you've touched on a very relevant point. So, what we try to do, because, you point out, which I think is inevitable, the decision is going to produce more TCRs, more tips, more information, more filings. So the SEC Office of the Whistleblower got over 4,400 in 2017 in fiscal 17. And if I had to guess, even without the decision coming down the way it did, I think it would have increased in fiscal 18. But with the decision coming down the way it did, and I don't want to speculate, is it going to go above 5,000? Is it going to go above 6,000? I don't know, but I can tell you it's going to increase. But your point, regarding volume, lends itself to this, and that is the SEC already deals, the Office of the Whistleblower already deals with an exceptionally high volume of matters, and they do it exceptionally well, given the volume and given the information. And a lot of the information comes in, half-baked. Some of it comes in, it's not baked at all. It's just, if I could use an analogy, here are a bunch of ingredients. I'm going to pour them on the table. You sort them out and make sense of them. It's supposed to be a cake. I don't even know what flavor or kind it is. Some of the information comes in a little bit more developed, or a little bit more baked. Our objective in what we do and the value that we bring to the table for executives and others who become our clients is we bake the cake as much as we possibly can. And if we can fully bake it, I mean, between myself and my partners, we have over 60 years of SEC enforcement experience, another 25 at the DOJ and 5 in-house in a corporate compliance office. So we try to bake the cake as much as we can. And the more fully we can bake it and the more complete it becomes, the more efficiently the SEC can use its own resources. So it can cut right to the chase. And of course, there's other additional work the SEC has to do. We're not a surrogate. We left the government. But that being said, we give the SEC as much information. We put together basically what operates as a prosecution memo, where we identify witnesses, we identify information, we identify key documents, we identify emails. We make suggestions as to where to look for documents, who to ask. We provide as complete a roadmap as we can. And I think in the wake of this decision, Tom, that these services will become even more valuable because the SEC is going to continue to try to use its resources in the most efficient manner possible. So, the people who are able to provide that kind of level of detail, those legal theories, the precedent, I think certainly are in excellent standing.
All I can say is, wow, the number of potential consequences from this Supreme Court decision really, we are just beginning to scratch the surface. And I am now convinced that, like I said, people like yourself will also be put under more pressure, in addition to the SEC, in addition to corporate compliance officers and corporate compliance programs, and frankly, corporations as well. So lots of consequences here, and it's going to be interesting to see how it shakes out going forward. Stephen, if someone wanted to get in touch with the firm or yourself, is there a mechanism by which they could do so? Is there something on link on the firm website?
Yes, the best way to get in touch with us, and also the best way for people to engage in self-education, is to visit our website. It's www.secwhistlebloweradvocate.com, all one word, secwhistlebloweradvocate.com. It's a dedicated website. I'm a partner at Labaton and Sucharow, which is, a very elite securities class action and antitrust firm. But our practice is part of Labaton and Sucharow. So the website, Tom, has a tremendous amount of information that my partner Jordan Thomas has spent years putting together, literally years putting together all kinds of information about the program, eligibility, securities laws, a primer on securities, and any other information. And then, of course, you can contact any of us directly through that website.
So I've been visiting with Steve Durham. Steve is a partner and whistleblower representation practice at Labaton Sucharow. He has significant government experience working with the SEC and now represents senior execs and other high-level folks in whistleblower cases in front of the Securities and Exchange Commission. We've been visiting on some of the impacts and consequences from the Digital Realty Trust versus Summers decision. It's been a fascinating exploration. And if there was ever a time to use my famous tagline, which was the discussion will continue, I think, Stephen, this is one situation where I look forward to continuing the discussion.
I do too, Tom. This has been very interesting, and please feel free to reach out if there's any other information or assistance I can give you or anybody else.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have any questions on this episode, you can email me at tfox@tfoxlaw.com. Also, if you would listen to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the oldest podcast around on FCPA and compliance. I hope you've enjoyed this episode. We're going to continue to explore the implications of the Digital Realty Trust decision over the next several podcasts, so tune in. I'm also going to release a white paper on this most important case as well, so look forward to that. Thank you again for joining me, and I hope you will join me again for the next episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network.